Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5216 et al. Edward Banks et al. Versus Quincy L. Booth in his official capacity as Director of the District of Columbia Department of Corrections, and Leonard Johnson in his official capacity as Warden, DC Department Corrections, Appellants, United States. Mr. Shefferly for the appellants, Mr. Marcus for the appellees.
Mr. Schifferly, good morning.
Good morning.
Please proceed.
Thank you. Good morning, and may it please the court, Carl Schifferly for the defendants. I would like to reserve 2 minutes for rebuttal. The preliminary injunction should be vacated for several reasons. First, it automatically expired by operation of the Prison Litigation Reform Act, the only issue on appeal being whether the injunction was entered in, quote, any civil action with respect to prison conditions. It clearly was. Alternatively, plaintiffs failed to establish the 4 requirements for preliminary injunctive relief, particularly where they failed to show the deliberate indifference necessary for a constitutional violation and Manila liability, both of which would be required to succeed on the merits. Even if all 4 factors were satisfied, the preliminary injunction was not narrowly tailored, and the district court later erred in denying reconsideration, failing to apply the requisite flexible approach and to recognize that changed circumstances warranted vacatur. As to the first reason, the PLRA applies here. It follows directly from how the plaintiffs presented their claims below and the district court decided them at the preliminary injunction stage.
Well, as you know, in the Southern District of New York, the court concluded that it did not apply where we're dealing with the COVID conditions. What's your response there?
So there are several responses. I would start with how the plaintiffs did characterize their claims, that their claims regarding the conditions of confinement, the conditions related to COVID, were claims brought under Section 1983, that their claims for release were claims under habeas. The district court granted the preliminary injunctive relief under Section 1983, conditions of confinement, but not as to the habeas claims for release. So we have that distinction. We also have the fact of applying that to the express language of the PLRA. It does apply with respect to prison conditions and further defines that phrase as any civil proceeding arising under federal law with respect to conditions of confinement. And
so as you know, and just help me here, the appellees say they have, in this case, raised habeas proceedings challenging the fact of confinement.
Well, as I said, the relief was granted on the Section 1983 conditions of confinement, not with respect to release. In any event, it wouldn't matter because the PLRA would still apply. This case is about conditions of confinement. It would exist but for conditions of confinement. It also follows from this court's precedent in Blair Bay and in Ray Smith, where the court recognized that conditions of confinement claims are, quote, precisely the type of claims that the PLRA sought to address. In those 2 cases, this court applied the PLRA, first of all, to mixed claims. That's where a conditions of confinement or traditional civil claim was joined with a habeas or other type claim. Those mixed claims, the PLRA applies. This court held. This court also applied the PLRA even to just habeas claims, where those habeas claims are based on conditions of confinement. Again, that's
so. Let me ask you then, what finding did the district court fail to make, in your view, such that her injunction would not extend beyond 90 days?
So it's not even contested that the district court failed to make the requisite findings under the PLRA. There's no argument from the plaintiffs on appeal that it was made. It was the need, narrowness, intrusiveness findings. The district court did not mention the PLRA or these requisite findings. It did not make the findings, the need, narrowness, intrusiveness findings. It didn't even.
Was any of this brought to her attention by the parties?
The district, in opposing the preliminary injunction, did alert the district court that under the PLRA, that these findings were necessary, that the court would have to make these findings. The court, was unable to or unwilling to make those findings, and so as a result, certainly the district court was on notice of this deficiency.
Thank you.
And so and the other requirement of the PLRA in order for the automatic expiration provision not to kick in was that the order be made final within 90 days. Again, no dispute that requirement was not satisfied in this case either. And so as a result, the preliminary injunction did expire by operation of the PLRA after 90 days. And I would again, this is not disputed by the plaintiffs at all on appeal. All that is disputed is whether the PLRA applies in the first place. And I think we've established, based on how the claims were presented below, the express terms of the PLRA, this court's precedent, which recognized not only the purpose of the PLRA in addressing conditions of confinement claims, but making sure that plaintiffs could not evade the requirements of the PLRA simply by dressing up their claims in a certain garb or joining a habeas claim or a claim for release with a.
Let me back you up to two things. First, on the New York decision, are you conceding that decision was correct? I mean, you distinguished the case, but do you need to? It's not controlling. So.
That's correct, Your Honor. It's not controlling. It's easily distinguishable.
Well, never mind distinguishable. You're not conceding it was rightly decided, are you? Or are you?
We are not conceding that. No.
Okay.
And
the second thing, as far as the suit addressing the fact of confinement, does it really address the fact of confinement when the whole basis for attacking confinement is the conditions of confinement? They didn't say you can't lawfully hold me. They said you can't lawfully hold us under these conditions. Is that not correct?
That's absolutely correct,
Right.
Your Honor. That this is the heartland of the PLRA. It's a conditions of confinement claim. This case would not be here but for conditions of confinement. In the complaint, the plaintiffs alleged a whole set of conditions that they sought to be improved. The only one aspect of that was downsizing. It was not even downsizing such that it would result necessarily in the plaintiff's own release. That was not necessary in order to ameliorate the plaintiff's injury. So it's not what was alleged below. It's not plaintiff's contention below. And even if it were, again, even if this were a no set of conditions case, the PLRA would still apply, but its own express terms and conditions, because this is an action with respect to conditions of confinement. And the PLRA recognizes as well that even in conditions of confinement cases to which it applies, release may sometimes be necessary relief. That's why it has a specific provision in paragraph A3 addressing prisoner release orders. So there's nothing that takes this case out of what the PLRA was intended to address, conditions of confinement. And this is exactly that type of case where the district court has entered a fairly broad injunction governing, large aspects of jail administration. This is what the PLRA was intended to address. If there are no further questions on the PLRA, I would like to address the merits quickly in my remaining time. There was no intentional or reckless disregard of the risks of COVID by Department of Corrections officials. To the contrary, the undisputed evidence was that the department immediately undertook extensive and broad measures, robust measures designed to address those risks based on the guidance of CDC, DC Health, and other experts. This included entry screening, suspending in-person visitation, educating inmates and staff on preventive measures, also testing, isolating, quarantining inmates based on the public health guidance, including quarantining all new admissions for 14 days. There was a medical stay-in-place order that was promptly implemented, limiting inmates to 1 hour out of cell time per day. there was a significant reduction in the jail population through the actions of the district and other criminal justice partners, decreased it by 16% within 3 weeks, by 27% within about the first 2 months. There's no dispute as well that the Department of Corrections undertook other policies and procedures with respect to social distancing and enhanced sanitation. And although the district court found fault with the implementation or enforcement of those particular policies, there was no dispute that the content of those policies were appropriate, and also that efforts had been made to implement and enforce them, even if those efforts were ultimately imperfect. And that is not a basis for constitutional liability, as this court has repeatedly held in cases like Franklin and Scott. At most, what is at issue is the failure of subordinates to implement policies, but that cannot suffice for constitutional liability. I do want to save some time for rebuttal, and I see that I am running low. If there are any further questions from the court, I'm happy to take them.
All right, Mr. Schifferle, we'll give you a couple minutes in reply. Mr. Marcus.
Good morning, and thank you, Your Honor. The district court's injunction was and is critically necessary to protect the health and safety of 1,500 Department of Corrections residents and hundreds of DOC staff whose union supported the issuance.
Does that address the motion for dismissal?
Yes, Your Honor.
Why isn't the motion well taken, the 90-day rule motion?
For two reasons, Your Honor. The first is the text of the Prison Litigation Reform Act.
Tell me what part of that text doesn't apply here.
The PLRA only applies to civil actions with respect to prison conditions, but expressly
Precisely, and isn't this a civil action with respect to prison conditions?
No, Your Honor. At its
not
core,
a prison action?
At its core, this is a habeas petition challenging the fact of confinement. There is no doubt that in this circuit—
Now, wait a minute, the fact of confinement or the conditions of confinement? As I read your complaint, you're attacking the conditions. You're saying you can't hold me under these conditions. You're not saying you can't hold me. Is that not correct?
Our complaint does address the very fact of confinement, Your Honor.
It says you can't hold us. It says you can't hold us at all.
It says that during the coronavirus pandemic, a disease that spread in congregate facilities like nursing homes, cruise ships, prisons, and jails, that COVID transmits rapidly in those settings. And so our petition did seek release for everyone, for all of the named, for the named plaintiffs and for all of the proposed class members in the action, on the basis that the mere fact of being held in a closed, cramped facility— being held in a closed, cramped. If they had not been held in a closed, cramped, would you have had a case at all? If the court had—
in home confinement or solitary confinement with hospital conditions, would you have had it? You don't allege anything about the fact of being held. You had alleged something about being held under these conditions, don't you?
Your Honor, I do understand that this is a bit of a gray area, but we did allege—
This is more of a gray area.
We did allege that the mere fact of being held in a prison facility, which by its very nature is a closed, cramped, congregate facility.
Okay.
The facts alleged in this case—
Okay, you're not going to get anywhere, so I'll leave you alone.
Well, I'll just direct the panel to the Sixth Circuit's analysis in Cameron versus Bouchard, which is directly on point here. In that case, the plaintiffs and petitioners brought a joint 1983 and habeas petition challenging the fact of confinement. And they alleged both that the conditions in that facility led to the claimed injuries and that release was the key remedy that the district court should grant. Now, the district court declined to grant release. It only issued an injunction that addressed the conditions of confinement. But nevertheless, the Sixth Circuit concluded that the core of that challenge was a habeas petition to the fact of confinement, even though the petitioners also challenged the conditions of confinement. Now, the application of that case in this district is even stronger, because in the DC Circuit, unlike the Sixth Circuit, petitioners can challenge the conditions of confinement in a habeas petition. That was this court's square holding in Amr versus Obama in 2014. All of the claims that the plaintiffs and petitioners brought here could be brought under habeas. Challenges to conditions of confinement are appropriate. And where the core of a challenge is to the fact of confinement. And where the core remedy being sought is release, the PLRA doesn't apply. And for this circuit to understand that the core was released, we direct you to the complaint and petition itself.
Well, that's what I've been looking at, and I want to know where I can find what you're telling me.
Your Honor,
Yes.
a couple of places in the complaint and petition. Paragraph 7, plaintiffs claim that downsizing is the only way to minimize harm done by COVID-19. Paragraphs 33 to 47, discussing generally the cramped conditions of prisons. And then paragraphs 133 to 138, which discuss specifically why downsizing is the only remedy that can provide relief to plaintiffs and petitioners.
I understand that, but I don't see the request for release of everybody.
That was the first form of relief requested, Your Honor, was writs of habeas corpus for as many members of the proposed class as would be necessary to safely allow for social distancing in the facilities. Precisely the same form of relief.
So you were recognizing there that others could be held under the conditions that would then prevail.
That's correct.
In other words, this is precisely about conditions of confinement, not the fact of confinement, because you do acknowledge in that part of your complaint even that the fact of confinement can continue. It's just the conditions of confinement that you're attacking.
I mean, that's in your prayer for release, for relief.
Yeah.
That's correct. The central argument was that release of a significant number of residents of DOC would be necessary for social distancing, would be necessary to cure the constitutional problems in DOC. Exactly the same kinds of claims Your Honor mentioned in the Southern District of New York in Fernandez-Rodriguez, and exactly the same kinds of claims that were brought in Cameron versus Bouchard. And I want to explain why this makes sense. Not just the text of the PLRA, which expressly excludes challenges to the fact of confinement here, but the purpose as well, is that when a petitioner challenges the fact of confinement, when a petitioner says release is the central remedy, that implicates the most serious liberty interest. And it would make sense for Congress not to erect the most significant gatekeeping to those kinds of remedies.
Would not we have expected, had Congress been thinking as you're saying, would we not have expected that this 90-day provision would have said that it does not apply in cases where the conditions are the basis of the habeas type claim?
Well, Congress did say it applies to challenges to conditions. So for instance, an action.
That's what it says.
Right.
And so that's what it says. And if they intended to exclude cases where those conditional claims include a recitation that you can let part of them go and keep part of them, wouldn't Congress have had some provision excluding those from the 90-day requirement?
I think that provision does exist in this exception, excluding challenges to the fact of confinement, where release for hundreds of people is the central remedy that Congress has already erected.
The order here that we're having the motion about did not involve release at all, did it?
That's correct.
It was addressing simply the conditions of confinement, wasn't it?
That's correct. But this
so doesn't this then constitute a civil action with respect to conditions of confinement?
I don't think so, Your Honor. And I think that looking at the relief that the court ordered is not what the text of the PLRA requires. The text of the PLRA requires looking at the proceeding, a civil action challenging or a habeas corpus proceeding challenging. And we think that's the analysis that should apply here.
You think you can take this out of the PLRA by joining your conditions claim with a plea for release?
Yes, where the core of the challenge is.
Wouldn't Congress have recognized that?
I think that Congress did recognize that by creating different regimes.
They just didn't write it down.
Well, Congress did create a regime for review of habeas proceedings, and there's significant gatekeeping hurdles to bring a habeas proceeding. the district court has to order a response in the first instance. So the district court regularly reviews petitions that might be frivolous. There might be exhaustion. In fact, there are exhaustion requirements for habeas proceedings. So it's not as if there aren't barriers set up for.
It would have been very easy if Congress intended to let habeas joinder take out the conditions claim for Congress simply to make a cross-reference.
Well,
that would have been a very simple thing if Congress meant to do what you're saying. That Congress meant to say you can put in some language about habeas and take the case of the civil action over conditions out of the PLRA. And that's what you're saying that Congress did, but we can't find that Congress did it anywhere.
We think that by including that phrase, excluding habeas petitions challenging the fact of confinement, Congress did recognize that
you ever heard Justice Scalia's remarks about mouse holes?
Yes, sir.
Okay, you think Congress hit an elephant that size in a mouse hole this small and this?
Well, we dispute that it's an elephant, as the Southern District referred to. These cases that address the fact of confinement are quite rare. And they have arisen during COVID because the very nature of the injury there, it does stem directly from the fact of confinement, being confined in cramped, crowded facilities. I did want to mention briefly why remand would be appropriate here and just direct the court's attention to Hudson versus Hardy. In that case, this circuit was confronted with a question of whether an action sounded in habeas or sounded in civil action. There, the district court did not have a chance to address the nature of the proceeding in the first instance. Here, the district court has not had a chance to address the application of the PLRA. And so we think that remand to the district court to ask these very probing questions would be helpful. And this court would have the benefit of a fulsome opinion to review on appeal, as is the normal course.
But counsel for appellants cited, what was it he cited where the PLRA was brought to the district court's attention?
So, Your Honor, I think that's not correct. I don't think that appellants raised this issue before the district court. Appellants, while their motion for reconsideration was pending before the district court, where appellants would have had every opportunity to alert the district court, we think the injunction has expired. And appellants didn't do so. They filed a suggestion of mootness in this circuit. And even when appellees said this issue would be best presented to the district court in the first instance, appellants nevertheless declined to present this issue to the district court. And so this court does not have the benefit of a district court opinion on this complex issue.
Your understanding is that this was only raised by the district in a motion for reconsideration?
No, the district declined to raise this in its motion for reconsideration. They raised the application of the PLRA in the first instance before the circuit.
Well, I just want to be clear, and I'll ask Mr. Schiffley about this. I understood him to say that the district had opposed the entry of a preliminary injunction by referencing the findings that were required.
The district court did oppose the preliminary injunction, but did not raise this issue, the application of the PLRA.
However, if they're correct, then this is a jurisdictional question, isn't it? Since we're talking about mootness, and jurisdictional questions can be raised at any time, right?
That definitely, Your Honor.
And the court's obligated, even if they're not raised, we're obligated to pass on jurisdictional questions, are we not?
That's correct. That was the exact situation in Hudson versus Hardy as well, Your Honor. The same question of mootness, the same question of how a petition should be characterized. And nevertheless, in that case, the circuit did remand to the district court to decide in the first instance.
There are no more questions. Mr. Schifferle, I know that Judge Rogers at least has a question for you.
Yes, Mr. Schiffley, you heard me in talking, saying I may have misunderstood what you said as to when the district raised the application of the PLRA while in the district court.
So in the district court, actually beginning even before the opposition to the motion for preliminary injunction, the district did raise the applicability of the PLRA. I did mention specifically in opposition to the preliminary injunction, and this is at page 39 of the defendant's opposition. The defendant specifically cited section 3626 and the requirement of need, narrowness, intrusiveness findings that they would have to be made in order to justify the preliminary injunction. And again, the district court did not or was unable to make those findings. Further, there was no dispute that the PLRA actually applied to the plaintiff's section 1983 claims. The district also raised an argument under the PLRA of failure to exhaust, and the plaintiffs did not suggest that the PLRA did not apply to their section 1983 claims. They argued that exhaustion had occurred, and likewise, the district court never even suggested the PLRA didn't apply here. It went ahead and decided exhaustion on the merits. And so it was clearly sort of raised and preserved, and the district court was clearly alerted below to this issue. I wanted to address, to continue my opponent's arguments that, first of all, this was not a case where a release was sought for everybody. There was no claim that the jail had to be emptied. There was no claim that the plaintiffs themselves needed to be released. There was simply a claim that the population should be downsized to some extent, but that was also simply to ameliorate a condition of confinement, that is to enable social distancing. So again, this is a conditions of confinement case. Also, that the plaintiff's argument, well, this could have been brought in habeas, is a moot point because the plaintiffs chose not to bring their conditions of confinement claims under habeas. They chose to bring it under section 1983. They made clear to the district court that that was the basis of their claims, and that's specifically at the April 22nd transcript at page 20, which we did cite to in our brief. That's where that that characterization was specifically made to the district court. I think, Judge Sentelle, you are correct that there is a concern here that if the PLRA can simply be evaded, if a plaintiff can simply tag on a claim for release under habeas to any conditions of confinement claim and simply say, well, I need to be released because of these conditions, then the PLRA could be easily circumvented in any case. Just by adding that on. And that's something that obviously should not be permitted. It's something this court did not permit in Ray Smith, and that should be followed here. I would finally just note the Supreme Court's decision in Porter versus Nussel, again, applying a very broad reading to a conditions of confinement claim. It applied it to a claim of excessive force, a single incident, applying it broadly. And again, in Porter versus Nussel, the Supreme Court recognized the importance of not allowing the PLRA to be evaded simply by clever pleading. And so.
All right, if there are no more questions, then counsel, thank you. Your case is submitted, and Madam Clerk, if you would call the next case.
Case number 21-5009, Scotts Valley Band of Pomo Indians versus United States Department of the Interior et al., Yocha Dihi Winton Nation, appellant. Mr. Adams for the appellant, Mr. Bergen for the appellee Scotts Valley Band of Pomo Indians, Ms. Jilla Kamari for the federal appellees.
All right, Mr. Adams, good morning. Please proceed.
Thank you, Your Honor, and may it please the court. Yocha Dihi seeks to intervene in defense of a Department of Interior Indian Lands opinion that denies the Scotts Valley Band's request for permission to develop a casino. As things stand today, the opinion shields us from significant harm to our governmental, cultural, and economic interests, harm that is set out in declarations that have never been disputed at any stage of this case. If Scotts Valley were to prevail on the merits, though, the opinion would be vacated. The matter would be returned to the Department of the Interior, and on remand, Interior would be prevented from applying the regulatory requirement on which the opinion is based. This is the significant historical connection requirement of 25 CFR 292.12b. In other words, if Scotts Valley wins, Interior cannot reach the same result on remand. We have a concrete particularized stake in the rule that's currently in place, and the threatened loss of that rule is imminent injury in fact under this court's precedent. On intervention as of right, the disputed issues are standing, impairment of interest, and inadequacy of representation. Unless the panel has other direction for me, I'll start with standing. Settled law, Crossroads, Fund for Animals, gives us a standing test for a party intervening in defense of agency action. Intervener has standing if it benefits from the agency action, the action's challenged, and an unfavorable outcome would remove the benefit, and that's what we have here. The opinion benefits Yochadihi by protecting it from harm. Scotts Valley has challenged it, and if Scotts Valley is successful, again, the opinion would be vacated, Interior would be foreclosed from reaching the same result on a remand. Appellee's primary reliance is on the Deutsche Bank case, but that decision does not control here. First of all, it was not a case involving intervention in defense of agency action. It predates Crossroads, doesn't change the rule that the loss of the favorable agency action is itself an imminent concrete injury in fact. Deutsche Bank is cited in Appellee's briefs for the proposition that if a threshold legal determination must come out a certain way, standing is less likely. But that statement had to do with whether the Deutsche Bank intervener had a contractual interest in the funds at issue in the case, not the question of imminence of injury, which is what's at issue here. Here, there's no threshold determination that's needed to establish Yochadihi's interest in keeping the opinion in place. That interest exists right now. And then finally—
excuse me, just 1 minute. Interest in the matter under litigation is, if you want the mandatory intervention, what is your interest that would legally protectable interest that would be involved in this litigation?
Yeah, so Your Honor, it is similar to the interest that was at stake in Crossroads. So we have an interest in the rule that's currently in place. That interest is concrete and particularized, and the injury—
What is your legally protectable interest? Don't tell me how it's concrete or something. Tell me what the interest is that's being legally protected, that's being legally involved. Legally protectable interest that's involved in this litigation.
Yeah, so peeling back the layers then. So what the rule blocks is significant harm to our economic, cultural, and governmental interests.
It's the worst that happens eventually is that a competitor comes into the field. Now, is your desire to not have a competitor in the field, is that a legally protectable interest?
It is in this case, Your Honor.
Yeah, I've litigated a lot of cases from various tables on the questions that are protected by economic law like Sherman Acts in this country. And the catchphrase has always been that American competition law protects competition, not competitors. And is there a legally protectable interest on the part of a competitor against the entry by a competitor?
Well, I think this court's precedent is fairly clear that there's a legally protectable interest when there is a dispute about the imposition or removal of a regulation.
Yeah, that's clear that if there is a change in the level of the playing field, that you have an interest in the level playing field. But here you're not asking us to protect a level playing field. You're asking us to protect the incumbent against entry of competitors into the playing field. And is that a legally protectable interest?
It is, Your Honor, and let me explain why. It goes back to the relief that Scotts Valley has requested here. So Scotts Valley has requested to vacate the opinion, but they've also requested that on remand to Interior be enjoined from applying the significant historical connection requirement of 25 CFR 292.12b, right? And that regulatory provision was enacted to balance the interests of established tribes like Yochadihi and restored tribes like Scotts Valley. So removing that regulation, which was designed in part to balance our interests, we think is a leads to a legally protected interest here. Appellee's other argument, of course, is that vacating the opinion would not give Scotts Valley the immediate right to build its casino, but Crossroads makes it clear that's not required. What matters under Crossroads is that the Indian Lands opinion conclusively denies permission for Scotts Valley's project and prevents it from proceeding. And for Yochadihi, that loss of that favorable decision is the imminent harm. And we would just point out that on that score, our position is even stronger than the Crossroads intervener. Crossroads, the federal defendant had some discretion to reach the same result on remand. But here, again, a Scotts Valley victory would prevent Interior from reaching the same result on remand by prohibiting application of the significant historical connection requirement. I see my time is ticking down. So just very briefly on the impairment prong of the Rule 24 inquiry, the issue there is, the district court overlooked circuit law saying availability of future proceedings is not enough to deny intervention, as well as, again, Scotts Valley's request to constrain Interior's decision-making on remand. On adequacy of representation, the bar is low, and we clear it because our interests are more specific than the federal government's. That's been enough in cases like Diamond, and because the federal defendants now deny that we have any interest in the case at all. So it's more than doubtful that they could represent our interests as this litigation goes forward. Unless the panel has further questions for me, maybe I'll reserve the remainder of my time here.
All right. Ms. Chilakamari.
Good morning, Judge Henderson. Actually, by agreement with the federal defendants.
Oh, all right. You go. All right, Mr. Bergen.
Thank you. Good morning, and may it please the court. Patrick Bergen for the Scotts Valley Band of Pomo Indians. Under this court's case law, an intervener must have standing, and to have standing, they must have an injury. And as Lujan stated, the injury must be concrete and particularized. It must be actual or imminent. The fundamental question before the panel today is whether vacating the Indian Lands opinion and remanding the case back to Interior would cause imminent harm to Yochadihi. The answer is.
Let me ask you, what about the request that the department be restrained on remand such that it could not make the type of argument that appellant maintains is protecting it here?
Thank you, Judge Rogers. So 2 points on that. First of all, that claim in our complaint is our second claim, and that's not one of the claims that Yochadihi wishes to participate in. Second of all,
hold on, you have to speak more clearly for me so I understand.
No problem.
Your client is seeking to have the department enabled on remand from requiring the conditions that are, as I understand it, precisely what appellant says protects it against action of your client seeking to build a competing casino. Does that change the legal analysis that the court has to apply?
It does not, Your Honor. Under the regulations, the Scotts Valley has to show 3 connections to the land in order for it to be eligible for gaming if that land is taken into trust. One of those connections is called a significant historical connection, and that requires simply that the tribe demonstrate that they have a significant historical connection to the land. This regulation is not something that's contained in the statute, and so out of the many claims that the tribe has filed in its APA action, it has stated that this requirement is inappropriate under the Indian Gaming Regulatory Act. But we've also asked, that the court remand because, for example, the department didn't follow its own regulations in making a decision with regard to Scotts Valley's case, or that it didn't consider the evidence in whole. Those are the tribe's 3rd and 4th claims, and those are the claims that Yochadihi says it wants to participate in.
I probably am not entitled to ask this question, but I'm going to anyway. Why do you care whether they intervene or not?
Well, Your Honor, the restored lands analysis really does not contemplate the involvement of third parties. The issue is whether or not Scotts Valley itself has enough connections to the land that Scotts Valley's project could go
How
forward.
would their intervention hurt your ability to raise that matter in the court? I'm not. I'll say I'm probably not entitled to ask you that. You may have some strategy that you don't want to tell me. So, but tell me you don't want to answer, and I won't be mad at you if you don't want to answer that one. But I am curious as to why it matters to you whether they get in or not.
Well, I'll be frank, Your Honor. The reason it matters is because there is an Indian canon of construction that says that if there is an ambiguity in a statute that the courts are supposed to interpret that statute favorably toward Indian tribes.
Mhm.
If there was more than one Indian tribe in a case, especially when they're on opposite sides, the court cannot possibly do that. So it's to our advantage to have only one Indian tribe in this case. Second of all, it's Scotts Valley's project. It's not Yochadehi's project. They were not the subject of the Indian Lands opinion. They're not really referencing the Indian Lands opinion. Their connections to the land do not matter to Scotts Valley's Indian Lands opinion.
Thank you.
Thank you. I do want to point out that, there actually may not be a benefit in this case at all to Yochadehi. And this kind of goes toward the imminence issue and also whether or not their injury is even concrete. As our brief points out, there are many hurdles for Scotts Valley to clear before it can open a gaming facility. And among these is an environmental review under NEPA and obtaining a Class 3 gaming compact with the state of California. If the environmental review shows that the proposed casino footprint is too large and not suitable for the area, Scotts Valley may have to open a smaller casino, which would of course be less competitive, if even competitive at all. And if Scotts Valley is unable to obtain a gaming compact with California, it could still operate gaming, but it would essentially be only able to operate bingo. And a bingo hall would be no match to Yochadehi's Las Vegas style resort. If there are no further questions, I think I'm at the end of my time.
Thank you.
Thank you.
Have I lost audio? Have I lost audio or?
I hear
All
you.
right,
I
then
can
Ms.
hear you.
I hear you.
All right, then Ms. Chilikamari, please go ahead.
Good morning, Your Honors. May it please the court. My name is Varu Chilikamari for the United States. Not all interests give rise to the right to be a party. And while Yochadehi may have a genuine concern about a potential future competitor, that concern is not a sufficient basis to make it a co-defendant in this APA challenge to a federal determination. Yochadehi has been given the right to participate below as an amicus, and we think that is a sufficient vehicle for Yochadehi to make its views known and considered in this court. I think there are a number of reasons.
There are differences between being an amicus and being an intervener. Intervener has rights in the litigation that an amicus does not have. So giving them amicus status doesn't satisfy their potential needs, does it?
Well, it's true, Your Honor, there are differences. We think that in this particular case, though, that ability to participate in
I'm like Judge Rogers. I'm going to ask you to slow down and speak a little more clearly, please, counsel.
Sure. So we think in this particular case, the ability to be an amicus actually does get them pretty far. For one thing, this is an APA case that will be decided on a record that's already been provided to the court. The agency's decision will have to rise or fall based on the arguments that the agency made already, not based on new evidence or post hoc rationalizations. The other thing to point out, though, is that one of the reasons I think why people want to become parties is the right to appeal. But under the DC Circuit's rule under Occidental Petroleum, a remand to the agency would not be considered a final judgment that could be immediately appealable. So I think it matters less in a case like this, whether they have, amicus standing, I think gives them all of the same ways to provide their views to the court.
So the concern, as I understand it, principally is that the court not limit the department on remand to the conditions it can require. Why isn't that a live controversy here, in the sense that appellant is not a stranger to the matter, that how are we characterizing it? The appellee, Scotts Valley, has made its intention clear. You know, so the ship is moving forward, and the terms of what the future proceedings involve are at stake. And yet, appellant can speak as a friend of the court, but not actually be a party.
I think I might have missed part of the question, but to start with, I think what the first part was about the ability to restrict the department's authority on remand. I do want to echo, I think, what Mr. Bergen noted, which was that Yocha Dehi has disclaimed any interest in, I think, arguing about that particular claim. At JA 96 is where Yocha Dehi says that it wants to limit its focus its participation on claims 3 and 4. Claims 2 of Scotts Valley's complaint is the claim that argues that the regulation is invalid. That would, if the district court found the regulation invalid and if the government didn't appeal, that would limit the department's consideration on remand. But Yocha Dehi has actually said that it focuses its participation on claims 3 and claims 4.
But we know, counsel, but you know what parties want to focus on and what courts do, and not always one and the same. So this is not some stranger being concerned, that's all. And I understand why Judge Sentelle limited his question to appellee Scott's band. But
I would
that's a little different, I thought.
Yes, I would say that, Your Honor, the question for the burden on the movement is to show that it's going to be injured if Scotts Valley is successful in the case below. And while Yocha Dehi certainly provided information at the administrative level, and that administration was considered, and Yocha Dehi may have concerns about the ultimate course of events in terms of a gaming casino, it is not going to be, there will be no real world impact. There will be no injury, even if the case is remanded. And even
I guess what I'm getting at is Judge Sentelle's point. There may be an injury, all right? But the sort of protection that appellant is seeking is not one that the law provides. In other words, they'd like to operate competitor free.
Oh, I understand, Your Honor. That, I think the district court assumed without deciding that competitive injury could serve as a potential, a concrete and particularized.
It can, but the question that I had was, does the competitive injury that the law protects against include the injury simply of the presence of a competitor, as opposed to some regulatory change that affected the levelness of the playing field? I don't think that's what you're addressing, and I think that's what Judge Rogers was asking you about.
I understand, Your Honor. I believe that the cases do, the DC Circuit does recognize competitive injury, and I think the test is about whether or not you're allowing a new entrant into the market. We didn't opine on this below, obviously, and the district court, I think, didn't as well. I think because the sort of first and foremost threshold question is, even if you assume that this would satisfy competitive injury, it's not imminent. It's a speculative whether or not the casino will even be built, will even get the relevant approvals that are necessary, because the Indian Lands opinion that's at issue in this case is simply the threshold determination.
Oh, I understand. I just wonder about the implication for this type of holding in other situations. That's all. At what point does someone who sees the ship approaching and the ship is not turning around has to stand by until the ship is literally upon it?
I understand. I think I would point the court to the Sokogan Chipaway versus Babbitt case, which is cited in, I believe it's cited in Scott's
Once
Valley's
again,
brief.
counsel, if you'll listen to how slow I'm speaking, that's how slow I listen too. So if you could keep that in mind as you're talking, please.
Yes, Your Honor. I would, on this question of kind of when can the parties stop a ship, I would point the court to the Sokogan Chipaway versus Babbitt case. It's cited in Scott's Valley's brief. The citation is 214 F3rd 941. That's a Seventh Circuit case, but it talks about this question of when you have a challenge to after the Indian Lands opinion. I think at that point you were in a land into trust decision, and there was a challenge by an intervener to the potential land into trust, which is the next step in this process. And the court, talks about how even then it's still speculative, and because we don't even know if there will be a casino in, and even if there is a casino, we don't know how competitive and whether it will actually be a successful casino. I think that's the best case I could point you to on that issue.
All right, so you're saying the law is that you have to wait till the casino is built.
I think in terms of standing, it's an elastic concept, and the courts haven't been that clear about it. I do think it is clear that this is definitely too soon, because we're at the threshold legal determination. And, unfortunately, because it is an elastic concept, I think as you get closer to it, the controversy sharpens. There is question about the subsequent step. For example, if the department granted the land into trust and actually took this parcel into, took title of the parcel for the tribe, at that point, you might have a more concrete injury. But certainly, I think the law is clear that at this point, when you only have an illegal opinion, an Interior Department opinion, that is too soon in the process.
If there are no more questions, Mr. Adams, why don't you take 2 minutes?
Thank you, Your Honor. I appreciate it. So a few clarifications. First, we have not disclaimed anything. As the federal defendants subsequently read to you, we have said we would focus our participation on certain issues, but those two words are not the same and they don't mean the same thing. Mr. Bergen mentioned that Scotts Valley has to show 3 connections. Just to sharpen the point that you and Judge Sentelle were making, the opinion already says they meet 2 of them, and they're seeking to enjoin Interior from applying the 3rd. So the dispute is pretty sharp at this point. Both appellees mentioned that there were additional hurdles. I think there was a mention of an environmental review process. Those hurdles are about how Scotts Valley operates its project, not whether it can conduct gaming in the first place. And more generally, of course, Crossroads makes it clear that the existence of additional agency decision-making does not preclude standing. That was a case where there were several rounds of agency decision-making between the loss of the favorable agency action and the underlying concern that the intervener had. On competitive standing, the cases are clear. If the competitors are in the same market, competitive standing exists. And here it's undisputed that Scotts Valley is seeking to enter Yochudihi's core gaming market. And then finally, on this Seventh Circuit case that the federal appellees mentioned, this is an issue where the distinction between the Seventh Circuit and this court really matters. Crossroads and Fund for Animals matter. Those two cases stand for the proposition that the loss of the favorable agency action itself constitutes imminent injury in fact. There's no equivalent rule articulated in the Seventh Circuit case, and the nature of the harm and the evidence at issue there were very different. Unless the court has further questions for me, I will rest there.
All right, thank you, counsel. Madam Clerk, if you would call the next case. And Judge Rogers, can you hear me?
Yes,
Okay, I have been fading in and out, but I'm paying close attention. So if 10 seconds go by and you don't hear me, would you take over? This is a longer argument, and I'm just afraid I'm having internet connection problems. So if I'm supposed to say something with respect to time, etc., and you don't hear me, then would you please take over?
yes, of course. Thank you.
All right, thank you.
Case number 20-1242 et al., New York Stock Exchange LLC et al., petitioners versus Securities and Exchange Commission. Mr. Mishkin for the petitioners, Mr. Totaro for the respondents.
Mr. Mishkin, good morning. Please proceed.
Good morning. Thank you, Your Honor, and may it please the court. The National Market System Plan amendments at issue should be vacated because they are unlawful rules that were promulgated without following required rulemaking procedures.
Don't you have a jurisdiction? I'm sorry.
Yes, Your Honor.
Don't you have a jurisdictional question before you get to that?
Yes, I'm happy to address that, Your Honor.
I wish you would, because if we don't have jurisdiction, we don't need to know anything else.
Right.
Go ahead, please.
The jurisdictional question fundamentally is whether this was rulemaking here. If it was rulemaking, then the court has jurisdiction, and we have every right to challenge that.
It should be slightly different in phraseology, whether the rulemaking time limit applies or the order time limit applies. The commencement, it's 60 days, I guess, either way. But when it commences, that's really the issue, not whether it's rulemaking. If it were rulemaking under the guise of an order, then you could have raised that in a petition for review of the order, and we'd have the merits in front of us. But since you didn't raise it timely under the ordering provision, are you properly here?
Yes, and we think absolutely yes, Your Honor, because we do think the question fundamentally is whether this was rulemaking, whether this was fundamentally a rule. The court confronts that question in different contexts and has to look at agency action and identify its substance and decide, was this in fact a rule? And if it was, I think the court's precedents are clear that we would be under Section 25B, because we're supposed to apply APA principles and decide if it's in fact an order.
So if it is in fact an order, you could have timely asked for review and raised that question to determine whether this is properly an order or whether it had improprieties in it for an order. But you didn't do that, did you?
We didn't, Your Honor, and that's because we have the right to challenge it under 25B if the substance of this was rulemaking.
Yeah, if you come out convincing us. But if we don't get to the question of whether it's rulemaking, it's styled an order. You knew it was styled an order. You had notice of what the commencement dates are for orders as opposed to rules. And you insist that you have the right to have gone with the rule for rules. But that doesn't explain why you did it. The fact that you have that you think you have a right to do something, particularly it's a disputable right, doesn't answer the question of why you did it. Why didn't you just bring it within the? It says it's an order. Why didn't you just go by what it said and challenge whether it's a proper order within the rules for orders?
Your Honor, the answer to that is that we thought we clearly had the right to challenge it as a rule, and I would direct this.
Do you think that's a good enough answer? As to
Your
why
Honor,
you did something is because we thought we had the right to? That's not a reason, counsel. I hate to tell you.
Your Honor, I think that if we have the right to do it, then we are allowed to do it. And that's the point I'd like to focus the court on. I think that in the Watts case, for example, this court, the order there was styled as an order, but the court said we don't actually have jurisdiction under 25A. And I think what that shows is that the same as would be the case when this court confronts this question in other contexts, is something actually an order or a rule? The court goes through a substantive analysis. And I think that the idea that we have to stick with what the commission said, and that if in fact it is not a rule, we must indulge in the fiction that it really was an order, I think that's a highly problematic result here, because you think about what that would result in, for example. That would mean
you
that
seem to be eliminating the concept that maybe this is an order that has an impropriety in it, which would have invalidated it. That seems to be what this could have been. Why isn't that the answer to what it could have been, rather than determining that it's styled an order, but it's really a rule?
Because, Your Honor, that's not the way this court looks at the difference between orders and rules. When it looks
Do you
at
think you know
something
more about how the court looks at things than I do? I think I've been looking at them the way as part of this court for 30 some odd years now. And
I understand, Your Honor. Respectfully, I would direct the court to, for example, National Association of Home Builders, which says we have not hesitated to consider an agency pronouncement issued without meeting required APA procedures a rule. And in that case, that was, if anything, a harder question, because that was a question about whether a pronouncement whether it counted under the Regulatory Flexibility Act. And it said in order to count, it had to be a rule that was promulgated according to certain procedures. And the court said, we don't hesitate to call that a rule. This wasn't a flawed order. It was in substance a rule. So that's what I mean when I said
it was an order, perhaps. It was an order in styling, at least. And if it was not a proper order, then why wasn't the proper way to have determined the impropriety have been to petition for review of that order, so that we could have the merits in front of us at that point? That you're asking us to look at the merits now, when it's very questionable whether the merits are in front of us.
Your Honor, I think, yes, we could have done that as well. But our point is that because 25B gives this court jurisdiction, according to the rules set forth in 25B, because that gives the court jurisdiction.
Let me say this. I agree with Judge Sentelle. You keep saying, yes, we could have done that. There was something you had to do when you got that order. And if you were so shocked that it was an order rather than a rule, then the first thing you should have done was challenge it and say, this is a rule, not an order. I mean, you lost your opportunity, and that's what statutes of limitation are for. You had every opportunity to say, you got it wrong, SEC. This is a rule rather than an order. But instead, you waited, and why you waited, we haven't heard. But your argument, well, we had a right to challenge the nature of it. Yes, but you had to do it in a timely way.
Your Honor, let me try to explain it like this. I think if the conclusion is that it can only be challenged as an order, I don't think that can be the right answer, because of what that would mean. That would mean that the commission could take something that was plainly a rulemaking and could characterize it as an order and never give notice.
No, SEC, you're wrong. I mean, you could have come up here in this 60-day period that you missed by 5 days or whatever and said, Circuit Court, please look at this. This is a rule rather than an order, and send it back. And for the life of me, I don't know why you waited, but there you are.
But Your Honor, I think the implication of that is that this court doesn't have jurisdiction under 25B. And that's what I'm disputing. I think the court does have jurisdiction under 25B because it is a very familiar exercise for this court to tell the difference between orders and rules. And if it was a rule,
the timing requirements on this have been held to be jurisdictional. So if we're looking at the rules as to when the time begins for the order, it's not timely. We don't have jurisdiction. If you didn't meet the jurisdictional requirement.
Well, I think the court does, because again, if it is in fact substantively rulemaking, then the court can treat it as such, and it would have jurisdiction according to the rules under 25B.
How can we get to the question of whether it's substantively wrong or not if we don't have jurisdiction?
Because I'm not this
You
initial
put us
question
in a
isn't
circle
about.
here that you're reasoning in a circle.
Well, I don't think so, Your Honor, because we're not asking to get to the analysis of whether it was right or wrong fully. We're asking a threshold question about whether this is properly in one bucket or the other. And I would say that this court has done that test again and again.
Have we ever done that? Have we ever done that where this was the issue? This question of whether being out of time for an order, for an action styled as an order, whether being out of time for that is okay because you decided you were going to have it asked to be given as a rule. Have we had any cases really parallel to that?
No, not specifically with regard to timing, but the bucketing analysis is what drives the jurisdictional question here. And so when you
say that the court has lots of precedent, we don't have precedent on this issue at all, do we?
Pardon me,
Nobody ever asked us to do this before, did they?
Well, the court, not in the particular application of this timing, but I think it is a very.
That's the question that's before us on this appeal. That's the first question. On this motion to dismiss, the question of dismissal question is timing. And we don't have a case on that at all, do we?
Not specifically with regard to timing, but I think
no would be the answer. Not specifically.
No, Your Honor.
Same answer
That's
is
right.
No, isn't it?
That's correct, Your Honor.
Okay.
But I think the other cases lead to one clear answer, because
but they all had the merits in front of them. The question now is whether we even have the merits, isn't it?
I understand, but I don't believe when the Congress makes a jurisdictional distinction, as it did in Section 25, between orders and rules, then this court necessarily has to confront whether something is an order or a rule. And that is an analysis, for example, that happened in Watts. It looked at whether something was really an order. Judge Urbina, it's not from this court, from the district court, Judge Urbina did that analysis with respect to a jurisdictional question in Levy, because whether it is properly considered to be an order or a rule, which will be a threshold question later for the merits, but whether it belongs in one bucket or another is what determines whether the court has jurisdiction. And I think it would be a very odd outcome if the commission could label something that substantively is rulemaking, call it an order, never publish it in the Federal Register, and then all of a sudden, and it could have all sorts of impacts on third parties. And then all of a sudden,
counsel, I don't think the questions that my colleagues have asked you have suggested that that could not be the ultimate result. The only question is what's before us. And you are not arguing, as some Supreme Court cases, that where an agency acts so far beyond its authority that the court can constrain the agency. That's not this case. Even if we were to accept your suggestion that what was done here was so obviously not an order that the court would have no discretion, essentially, other than to agree with you. And you would have to come in a second proceeding. The only thing I could think of is you were trying to cut out sort of a middle proceeding because you were so confident you would win in the end, at least as to whether this should have been rulemaking rather than an order.
Your Honor, I think that this is, if you look at the cases that distinguish between orders and rules, some of them are closer because there are factors pointing in both directions. This is not a case where the factors point in both directions.
But that's, well, I won't repeat, yeah. Okay.
If I could give the court this hypothetical, just to try to underscore the point as to why this was so obviously rulemaking. And again, we think the case law is clear that if it was rulemaking, the court has jurisdiction, which is the question that we're focused on. But imagine a hypothetical. Imagine the commission one day had come out with a 3-part order, and it said part 1, SROs are limited in who their plan reps can be. Part 2 said the SROs are limited in what kind of information they can share internally. And Part 3 said everybody in the world who interacts with the plans have to make certain disclosures. And there a lot more occurred here. But imagine that was the order. I don't think that this court would have any hesitation in saying that the commission had engaged in rulemaking. I think that is
Let me
more
ask you this. Do you think that any lawyer in the world, or why would any lawyer in the world wait past the deadline difference to bring that to us? Such a hypothetical has more to it than you may want it to, counsel. That would raise the question we're raising with you. Why did you not act consistent with the rules, and there's only a 5-day difference? What in the world were you trying to do by putting this in that 5-day, what might best be called a gray zone?
Your Honor, we don't believe it's a gray zone. I think that if you look at
that, I don't believe that's an answer to my question. Your
that's the best
hypothetical,
answer I
when
can
you
give
parade horribles, you got to make sure they're horrible. And would it be horrible for us to expect counsel to expect an entity to bring the petition under what is applicable rule according to the name on the document before we ever get to the merits?
Your Honor,
I just don't find your hypothetical to be connected enough to the real world to have a lot to do with the answer to the question.
my point is that it's a purely legislative, forward-looking determination. And if you look at, I think it's more clearly a rule than the enhancement findings in Safari Club.
You're still arguing the merits and not the motion.
I guess, Your Honor, respectfully, we don't view when Congress creates a jurisdictional distinction at the outset, which cannot be driven by labeling. I think the court has no choice but to do the bucketing. And if that bucketing clearly leads to a conclusion that it's rulemaking, the court has jurisdiction. I don't know why the court would defer more. Let me leave the court with this thought. I don't know why the court would defer more to a commission characterization in the context of rulemaking than in the context of a jurisdictional question than it would in the context of anything else. And that would be the effect here. If the court is going to say that there is no jurisdiction over something that the commission labels an order, which would be the effect of the implication of these questions, then I understand it's a different case. But what that would mean would be that the commission could characterize its rulemaking as an order and deprive the public.
It's not just deference. If we look at what's before us, it is an order unless we say it's not an order. So at the time you have to make your decision to petition, it's an order. It may turn out that we're going to say, no, it wasn't properly an order, but you're putting us into a circuitous reasoning here to say, well, it's not an order because we're going to say it's not an order, but it is an order until we say it's not an order. I don't know if I want to get on that circus, counsel.
Right. I think that it's a very, when something has no components of an adjudicatory proceeding and it is rulemaking in every way that it appears to be, then I think that the court has jurisdiction over that. I think that's exactly what 25B is saying.
Can I ask you about Rule 608?
Yes,
D,
Judge Henderson.
which is the appeals. And of course, that's no longer timely, but wouldn't you, under D, could you proceed under D?
I'm sorry, Your Honor. Can you repeat that?
608D, appeals. The commission may, in its discretion, entertain appeals in connection with the implementation or operation of any effective national market system plan as follows, and then it sets it out. I mean, could you have sort of stayed with the agency before?
Your Honor, we viewed it as a final rule, so there was no need to take it up further with the agency. We think it's completely proper if the agency engages in rulemaking, it can be challenged under 25B. So that's the route that we took.
Give you a couple.
I see I'm over time, so I'd like to reserve a bit of time for rebuttal, but I'll yield at this point.
Well, Mr. Totaro.
Your Honors, and may it please the court, Martin Titaro on behalf of the Securities and Exchange Commission. Judge Sentelle is correct that petitioners seek to put the merits cart before the jurisdictional horse. Petitioners agree that these agencies were orders, but try to argue that they should have been rules. That argument could have been raised in a timely petition for review, but petitioners chose to file after the statutory deadline. As a result, the petition should be dismissed as untimely. I think the two best cases for us on this point are this court's decisions in British Caledonian and New Star. Although, as Judge Sentelle noted, this issue doesn't arise a lot because the prudent thing to do would be to timely file, challenge the rule, and challenge it as unlawful. And so in British Caledonian, the court ruled that because the agency issued an order pursuant to a regulatory scheme, the court would accept the agency's label of the order. It said, and this is on page 992, the order in question is what the agency states that it is, but that doesn't end the inquiry. The court then went on to decide that the order was invalid because it should have been done as a rulemaking. And so here, petitioners don't even get to that second step because they cannot satisfy the antecedent question of whether there's jurisdiction in the first place. And similarly, in New Star, the court addressed whether an order was arbitrary and capricious because petitioners claimed that it should have been done through rulemaking. In both cases, the court asked not whether the order was actually a rule, but whether the order was invalid because it should have been done as a rule. Here, the commission followed the plain text of Rule 608B when it issued the orders on review. 608B2 says that approval of National Market System Plan amendments initiated by industry shall be by order. Now, 608B2 also says that the commission can make, quote, changes to a proposed amendment filed by stock exchanges that the commission deems necessary and appropriate. And that is precisely what happened here. Industry proposed the amendments, the commission approved the proposals with changes, and the commission issued the approvals by order. Petitioners did not seek review of those orders within 60 days of their entry, and thus they are time barred as a matter of jurisdiction because they failed to satisfy the plain terms of Section 25A. I'm happy to answer any questions this court might have.
I have one, Mr. Totaro. If we rule with you, these are fairly far-reaching changes that the commission made. Would it be open to the SROs, two of them at least, to propose amendments that either got rid of these changes or wanted a second chance to explain why they are so far-reaching?
Judge Henderson, you are correct. So under Rule 608A1, any two or more self-regulatory organizations acting jointly may file a proposed amendment, and nothing in this court's decision dismissing the petitions as untimely would prevent the exchanges from complying with that part of the regulation.
All right, thank you. If there are no questions, Judge Sentelle? Judge Rogers?
Oh,
And Judge Sentelle, all right, well, we
No
have your
questions.
argument.
Fine.
All right, we have your argument, Mr. Totaro. Thank you.
Thank you, Your Honor.
Mr. Mishkin, if you want to take a minute, go ahead.
Yes, thank you, Your Honor. I think the flaw in the reasoning here is the idea that when this court is looking at whether something is an order or a rule, and it determines that it's rulemaking, that it considers it to be a flawed order. I think respectfully, that is not what we see in case after case. And I don't hear anything in what Mr. Totaro said that would address how this court approached this in National Association of Home Builders, which was to go to the substance, to say that there was something that should have been done through rulemaking, was not, and we're going to call it a rule. The answer was not that it was a flawed order. It was that we're going to call it a rule. And I think that what that reflects is that this court looks to the substance of what the action actually was. That's not the merits question here. The merits question would be, okay, if it's a rule, did they go through the right procedures? I think it's a discrete initial question, and I think it's an inevitable question when you have the two sections. And again, Watts shows that this court does not defer to an agency label. We know that from all of these cases. And I think if the court were to deprive itself of jurisdiction over something that's challenged in the right way for a rule, that would lead to mischief, because then the commission could not give notice to people affected by something, never publish it, wait 60 days, and then the time would run on their theory, even though it was rules, even though rules are rules and it would be unmistakably a rule. I think that would be the wrong result.
You are wrong about that because they are required to be published in the Federal Register. And if they are not, then they are not effective. But we've got your argument. So thank you, counsel.
Thank you.
This honorable court is now adjourned until Thursday, May 13th at 9:30 a.m.